I'm Christina Jump, and I am the Civil Litigation Department Head for the Constitutional Law Center for Muslims in America. And today I want to go ahead and speak with you about religious accommodations in the workplace. Several of the other presentations have touched on this, but today we're going to address it directly and talk about what is involved and what is required, what is permitted, and what is not. So let's go ahead and get right into it. First, where we begin at the beginning is Title VII. Title VII of the Civil Rights Act of 1964 protected categories, things that may be causes of discrimination in the workplace. This applies to workplaces that have 15 or more employees, and it prohibits discrimination on the basis of race, color, religion, sex, gender. That's not sexual orientation, but that can be sexuality or just gender, basically, and national origin. And for our purposes today, we'll be focusing on religion. Religious accommodations under Title VII mean that employment discrimination can include refusing to accommodate an employee's sincerely held religious beliefs or practices unless the accommodation would impose an undue hardship on another. And what is required in order to get an accommodation, in order to show an accommodation? What are employers required to do? Well, requesting an accommodation under Title VII allows an employee to enjoy the same benefits as other employees, but not more. The same, no less, no more. The employer does not have to grant the accommodation that the employee requests. It doesn't have to be that specific accommodation. It does have to be something that will address the sincerely held religious belief and is reasonable for that workplace. Accommodation that is requested in order for it to be considered a reasonable accommodation cannot cause an undue hardship on the employer. There are a couple of things that the courts look at to determine what is an undue hardship. It cannot impose more than a de minimis burden, which is the Latin and legal term to mean no heavy burden, no severe burden, no more than just a little bit. It can be a little bit inconvenient, that's okay, but it cannot impose a great burden or hardship on other employees or a great financial burden on the employer. And what is most commonly evaluated is the impact on other employees. Some examples that have come up in the case law are truck drivers who, for religious reasons, do not want to be placed driving overnight with someone of an opposite gender. That in a truck driving position, which is a long haul driver position, is considered to be something that is an undue hardship and would put an undue burden on other employees. So courts have said that for that job position, that is not something that an employer has to accommodate to make sure that the driver's never paired with someone of the opposite gender. Another example is truck drivers or long haul drivers. This comes up a lot. They make a lot of the religious discrimination case law in that particular profession. But truck drivers or long haul drivers who do not want to work at all after sundown, for a job that requires driving and making progress as much as possible throughout the day within the limitations imposed by OSHA for safety and by the Department of Labor generally. It is not really considered reasonable to say that those drivers don't have to drive because that is the main primary essential function of the job. So a religious accommodation still has to allow for the individual to perform the essential functions of the job with a de minimis or with a minimal burden placed on others. And as with not wanting to be paired with a fellow driver of the opposite gender, not wanting to drive at all after sundown is not considered in the truck driving context to be a reasonable accommodation. Another example that's come up, and there wasn't really a request for accommodation made on this one, but it hit the news, and it is something that I want to address, and it has come up in employment situations. Mike Pence, our vice president, mentioned that he does not ever want to be alone with any woman who is not his wife. So he won't hold meetings where it would just be he and one other individual who happens to be female. He doesn't want to be at dinner with just another individual who happens to be female, unless he has his wife with him or he has other people there as well. And there are certain religions that require that or that prohibit being alone, where, for example, a married woman should not be alone with a man who is not her husband, or any woman may not, depending on the specific individual's sincerely held religious beliefs, where maybe any individual, any woman might not be comfortable or would consider it to be a violation to be alone with any man, whether she's married or not, and whether he's married or not. And again, courts will look at whether that imposes an undue burden on other employees. Now, as we said in the truck driving context, that's something that's very difficult to accommodate. So that's something that probably a long haul truck driver would not be an ideal occupation for somebody with those religious beliefs, because it's difficult to impossible to accommodate that without imposing a more severe burden on other employees. But in an office environment, that should certainly be possible. In the standard office environment, it's probably likely that there doesn't need to be any time that the particular individual is alone with someone of the opposite gender. Now, if this is a position that requires travel, they're both in a position that requires travel, they happen to be of opposite genders, and it is not the company's standard practice to pay for additional individuals to travel along with them, then that may be something that is difficult to accommodate, or the accommodation may mean sending someone else on that travel. That may be something that could be considered a reasonable accommodation in that setting. Now let's look at dress code. This came up most visibly, notably in the Abercrombie & Fitch case. The U.S. Supreme Court decided that Abercrombie & Fitch's look policy did not appropriately prohibit an individual from wearing a headscarf. So there's a Muslim woman who had applied to be a cashier at Abercrombie & Fitch, and the hiring manager for that particular store had noted on her application that she met all of the appropriate boxes except for the headscarf, and he wasn't sure, and he sought guidance and clarification from his superiors as to whether that fit what they called their look policy. Now, Abercrombie & Fitch does sell clothing. They do sell a certain look, and so his question was, does wearing the headscarf violate our look policy? Abercrombie & Fitch determined that it did. The individual sued. It did go all the way to the Supreme Court, and Abercrombie & Fitch lost, because the woman could still wear Abercrombie & Fitch clothing. She could still portray the brand and wear her headscarf. There was nothing that prevented her from being able to work the cashier while wearing a headscarf, or work the cash register. There was nothing that prevented her from being able to sell the clothing or even to wear the clothing. It wasn't contradictory to anything that Abercrombie & Fitch was selling, and the Supreme Court determined that there was nothing there that was a legitimate reason for the store to say no, because of the headscarf she can't be employed here. Another case that the Supreme Court has addressed is Holt v. Hobbs, which determined that an individual could grow a minimal beard, a half-inch beard, since there was no compelling reason to prevent that, and it did not present a hardship. Now, this was in a prisoner context. As to prisoners, the logic has been applied in employment, and in fact, we have a case with an individual who's in the military, where the military changed its policy. Happened to be shortly after we sent a demand letter, and after we were through, as the deadline was approaching that we had given them before we were going to be filing a lawsuit to seek an accommodation for that individual to keep a neatly trimmed beard. Don't know specifically that that lawsuit is the one that triggered that, but I can say that it didn't exist before, and then the policy was changed, and we did not end up having to file a lawsuit on behalf of that individual, because he did end up getting the policy changed to meet what he wanted and should have had, that he could wear a neatly trimmed beard for religious reasons, as long as it did not interfere with his duties. There may be situations where that would interfere, such as in the food industry, although again, typically that would be more focused on, for example, wearing a hairnet or wearing something that constrains the hair so that it wouldn't interfere with the food processing, but that is something that would need to be looked at, where perhaps it would not be an available reasonable accommodation for an individual to keep that. Even Disney had to learn. Disney got in trouble for the restrictions on its uniforms a few years ago. They were determined not to be reasonably or necessarily related to job functions of the positions. Disney attempted to create a uniform scarf, and it didn't go so well for them, so they discontinued that. It was a little hard to meet everybody's requirements by creating a uniform scarf. So what about prayer times? That is something that does come up. If an individual wants to pray multiple times during the day, how does that impact the work environment? Well, it might be possible to have the individual change shifts. It is likely not possible to give the individual additional break time beyond that which others would have. But it could be possible to divide that break time. So instead of it being 1 hour for lunch, perhaps it's 30 minutes for lunch and 3 10-minute breaks throughout the day, if that's something that would fit with the individual's needs and with the needs of the employer and of the workplace. Again, you need to look to the comparators in the office or other branches and see what is something that fits that environment. It can cause, it's not to say that it can't cause any burden on others, it can't cause any hardship. It can cause people to be a little uncomfortable or need to rework things or do things they haven't done before, but it should not be an undue hardship, and courts are specifically stringent about this if it comes to placing a burden on other employees. So ideally, this would be working to trade break times or to offset times when others can have the same option or same break opportunities. Now, for religious expression in the workplace, there cannot be anything that seems like a representation of the government. This comes up when a lot of times we have clients who work for government entities who will come to us. And there should not be a favored religion by the government. There should not be a display for one religion only. There should not be a display that appears to be a representation of the government. This came up for us in one case where an individual felt that she was being forced to participate in a Christmas gift exchange and to place a stocking at her cubicle and do a secret Santa and bring Christmas cookies to the Christmas party that began with a prayer thanking Jesus. This is all public record, and so not a secret that we did, in fact, on that one, need to bring a lawsuit. We were able to reach an agreement and to get those policies changed, and that particular government entity, and I believe others as well, no longer requires that, and also did, at our urging, change its policies to require additional training and additional religious sensitivity training so that that could not become something that was mandatory in the workplace or even strongly encouraged by anybody in a supervisory position. Now, if you look at what is somebody's recourse, what is something that you can do? If you feel that you need a religious accommodation, you would like a religious accommodation, and you don't see that it's going to cause any great burden on other employees or on the company itself, what is something that you can do if you've tried that internally and didn't get it? Well, first of all, make sure that you follow whatever the complaint procedure is at your place of employment. Most employee handbooks will have a complaint process or a request for accommodations process that is set out within it. If not, double check the company's website. If there's an internal employee-only portal that's available, double check that. And if there's still nothing visible, go to Human Resources, go to the individual supervisors, go up the chain and say, this is what I would like, and it is because of my religious beliefs. You need to show that you gave the employer the opportunity to work with you, that you tried to work it out and gave the opportunity a chance to do the right thing, and that they were informed. Because if a company has an accommodation process in place and an employee does not attempt to use it and then just quits and says, look, I wasn't accommodated and I had to resign because I wasn't able to effectively stand by my religious beliefs, the courts are going to be pretty skeptical if the employee never went through what the available process actually is. So making the employer aware and making an effort to go through the process that's already in place is something that is necessary first. For an employer, on the flip side, going through that in good faith is also necessary. It's not necessarily just saying, this is one accommodation that we can offer you, take it or leave it. Listening to the employee and having a discourse back and forth is something that's very important to show good faith in that process. If all of that fails, then an employee needs to file a charge of discrimination with the EEOC or with the comparable state entity. Within Texas, that's the Texas Workforce Commission. A lot of states have their own version of a workforce commission or a human rights commission that have a state version of filing a charge of discrimination or a complaint. That can be done during employment while the individual is still employed. That also can be done after employment if it's done within a reasonable time. And eventually the individual can sue after completing those steps first. So if those steps haven't been done, then there's not going to be a claim that a court will hear. But if those steps are taken care of, then an individual will be in a pretty good place to make a claim that the employer failed to reasonably accommodate sincerely held religious beliefs. All right, so I want to thank you very much. I appreciate you being here and appreciate you tuning in to hear the basics of religious accommodation in the workplace. I hope that this was helpful, and you are welcome to contact me as well. Again, I am Christina Jump with the Constitutional Law Center for Muslims in America, and you can reach us at clcma.org through our website. And we do have an intake form for any individuals who are seeking representation. And we do require that everybody who would like to seek representation go through the process of filling out that intake form. Otherwise, you can just go to our website, see what we do, find out more about us, and certainly contact us through that means as well. Thanks very much. I hope all are having a good day. Stay safe and stay informed.